Good afternoon, everybody, and welcome to the weekly press briefing of the Kosovo Specialist Chambers, where we aim to provide journalists with an update on the latest developments at the court and the opportunity to ask questions. On 19th February, the president of the Specialist Chambers, Judge Ekaterina Trandafilova, decided to modify the sentences for Sabit Januzzi and Ismet Bakhtiari and provided for their release on 21st February 2025 under the conditions described in the decisions. These conditions will continue to apply for the remainder of the 2-year sentence imposed on the accused after the trial panel had approved their plea agreements with the specialist prosecutor on 4th February 2025. Mr. Januzzi and Mr. Bakhtiari had admitted guilt to obstructing official persons in performing official duties and to intimidation in criminal proceedings. After a convicted person has served 2/3 of their sentence, the president of the Specialist Chambers may consider a commutation, modification, or alteration of the sentence. Mr. Januzzi and Mr. Bakhtiari had served 2/3 of their sentence on 5th February 2025. President Trandafilova reminded of the gravity of the offenses for which Mr. Januzzi and Mr. Bakhtiari were convicted, given the impact of witness intimidation on the administration of justice. In the trial of Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi on charges of war crimes and crimes against humanity, the trial panel on 24th February authorized the prosecution to continue disclosing evidence requested by one of the defense teams to all defense teams, as it was the practice thus far. The panel was satisfied that the timely disclosure of material the prosecution intends to use in re-examination ensures that the defense has adequate notice of such material, no matter on which specific rule the disclosure was based on. On 26 February, the trial panel granted in part the admission into evidence of certain exhibits concerning the organization of the KLA in Drenica zone, based on their authenticity, relevance, and considering the panel's finding that the admission into evidence of these documents does not cause any prejudice to the defense. The panel denied the prosecution's request concerning exhibits that, in the view of the panel, lacked authenticity. On 21st February, the trial panel granted in part a similar motion by the prosecution concerning evidence related to the lab zone and ordered the prosecution to amend its exhibits list by no later than Friday, 28th February. On 26 February, the panel denied a joint request by the defense to take measures to ensure the appearance of impartiality of the proceedings and avoid prejudice to the defense. The panel reminded that it cannot be expected to entertain abstract allegations that are neither substantiated nor detailed, and noted that the defense did not challenge any decision by the panel or raised any concern of impartiality in regards to any question the panel asked. The panel further noted that the rules set no time limit for the panel to ask questions to a witness, and underlined that in many legal systems, the bulk of the questions comes from the court. The panel noted that the defense has not identified any one question put by the panel to any of the witnesses mentioned in the defense motion that was not relevant or not conducive to the search for the truth. The panel highlighted that its questions can lead to either incriminatory or exculpatory evidence, or matters of clarification, or issues pertaining to the credibility of a witness. Questions are asked to elicit evidence which the panel considers relevant and necessary to the fulfillment of its truth-seeking duty. Concerning the allegation of posing leading questions, the panel pointed out that the only example the defense gave for this allegation concerned a witness that had to be repeatedly reminded to answer the questions And in this case, the panel used leading questions to keep the witness focused on the question being asked. The panel reminded that it is their duty to assess the credibility of a witness and the reliability of a witness testimony. To preemptively limit the panel's questioning would seriously interfere with the panel's role as a neutral fact finder. The next hearing in this case is scheduled for Monday, 17th March, starting at 9 in the morning. In the Thachi et al. Case concerning the alleged influencing of witnesses, the appeals panel on 25th February granted Mr. Smakai's and Mr. Fazliu's request for an extension of time to respond to the prosecution appeal against the decision on the confirmation of the indictment, and authorized the defense of the two accused to file their responses, if any, by Monday, 3rd March 2025. The panel further ordered the reclassification of their request to public. The appeals panel recalled that the issues on appeal would significantly affect the outcome of the proceedings, and that it is therefore in the interest of justice to allow the newly assigned counsel of Mr. Smakai and Mr. Fazliu the time to familiarize themselves with the case so they can submit meaningful responses to the appeal. On 21st February, the pretrial judge in this case granted a joint defense request to further extend the deadline to file preliminary motions. Such motions may, for example, challenge the jurisdiction of the specialist chambers or allege defects in the indictment. Basis for the decision was the fact that the appeals panel has not yet ruled on the prosecution appeal against the decision on the confirmation of the indictment. The trial panel set the new deadline to 21 days after the appeals panel issued its decision of if the appeals panel upholds the decision on the confirmation of the indictment in its entirety. Should the appeals panel rule differently, the pretrial judge will issue a new scheduling order. On 25th February, the Supreme Court panel dismissed in its entirety Salih Mustafa's and the prosecution's requests for protection of legality. While Mr. Mustafa had requested that his overall sentence of 15 years imprisonment be reduced, the prosecution alleged that by imposing a new sentence of 15 years, the appeals panel had substantially violated the procedures as it failed to provide a reasoned opinion. The Supreme Court observed that the appeals panel in its decision on new determination of sentence specifically followed the findings set forth in the previous Supreme Court decision, the sentencing range identified therein, as well as the relevant international jurisprudence. The panel further recalled that the circumstances surrounding the crimes for which Mr. Mustafa was convicted, including murder, were extensively considered by the trial panel and twice by the appeals panel. Therefore, the panel was of the view that Mr. Mustafa failed to demonstrate how the appeals panel could have come to a different determination of his sentence, and found that he failed to identify how the 15-year sentence constitutes a violation of the criminal law. The Supreme Court further concluded that the prosecution did not demonstrate how the appeals panel failed to adhere to the Supreme Court decision, and observes that the appeals panel extensively reasoned its decision and referred to the guidance given to it in this respect. On 21st February, the single judge overseeing the implementation of the reparations order in this case ordered Victims' Counsel and Registrar to provide public redacted versions of several filings related to the reparations order, and to submit in writing if they are of the opinion that some of these filings should not become public, including indicating whether and when they foresee that public redacted versions of the filings are possible. That is all from me for today. If there are any questions, I'll be happy to respond.